think I see counsel for the next case, all present. This is Lakeshore Group versus Department of Environmental Quality and Dune Ridge. Mr. Ordway, and then we have Mr. Bach and Mr. Konwinski. You each have 20 minutes, and we will start with you, Mr. Ordway.
Thank you, Chief Justice. Good afternoon, Chief Justice and Justices. May it please the court, I'm Dustin Ordway, appearing on behalf of appellants, Lakeshore Group and its members, who are the petitioners below seeking a contested case hearing on multiple permits for development in Saugatuck in an area that is designated by statute to be protected critical dunes. I would like to reserve 5 minutes, if I may. My goal in the next few minutes, the beginning of this discussion with you all, is to do two things. First, appellants ask the court to include 3 rulings in your opinion. And I'll go through these very briefly, and then what I'd like to focus on primarily is statutory interpretation. First, we ask that you rule that petitioners do satisfy the standing provision of section 35305, that they are owners of property immediately adjacent to the proposed use. Second, we ask that you rule that the administrative law judge got it right the first time he issued one of several decisions in October 2015, 5 years ago, in which he held that petitioners had standing, and he also held that the regulated party, the permit applicant, now the respondent, Dune Ridge, could not use a buffer defense to avoid the review in a contested case process of the permit decision-making by the department. And then third, we ask that you hold, and this goes specifically to the question the court has posed, that where parties have standing, actions by the regulated party that do not go to the subject matter of the case cannot divest the parties of standing. In this case, the developer sold off 2 small areas that were not part of the locations where the permitted uses were to occur, and then filed a motion with the ALJ saying, you said we couldn't avoid review of the buffer, but now we don't own the buffer anymore. Therefore, please dismiss the case. And he, we believe, made a mistake in doing so. And the Court of Appeals, we think, is wrong in agreeing with him. The circuit court we submit got it right. The circuit court ruled that at least 4 of our petitioners did have standing, and the case should have gone back for a contested case hearing. If I may, I'd like to drill down much more rigorously than we have done before into statutory interpretation. And we're mindful of the admonitions of the court that the purpose of statutory interpretation is to discern the intent of the legislature using its own words, and to look at those words as the legislature has used them, and to attempt to reconcile all words of the statute so that they all make sense as one comprehensive whole. What I had just butchered is stated much more clearly in, for example, the decision of this court in South Dearborn versus DEQ in 2018. So the question before the court is, when asked to interpret whether a party has standing, the question is, are they an owner of property immediately adjacent to the proposed use? That's the language of 35305. And what I'd like to do very briefly is just go through the words in that phrase. Owner is not defined. I'd like to circle back to that later. Adjacent is perhaps the key term, and adjacent is not a defined term, and therefore under standard practices of statutory interpretation, we would look to the ordinary meaning or dictionary used. One Merriam-Webster definition of adjacent is near or close, especially without touching. That causes us to ask, what did the legislature mean by immediately adjacent? We submit that discerning the legislature's intent with that 2-word phrase, one has to look at what they related it to. And what they said was immediately adjacent to the proposed use. Use is the one word in this standing provision that is defined. It's defined at 35301K, I believe, as the activity that requires a permit And it's defined in terms of it's having an effect upon a critical dune area. When the Sand Dunes Protection Act was promulgated in 1989, DNR had created maps of critical dune areas that the legislature deemed worthy of special protection. Critical dune area is a key term throughout the statute. It's used many times. And we submit that the simplest and most obvious meaning of the standing provision, that if someone is an owner of property in the same critical dune area, then they are effectively immediately adjacent to the proposed use. And we would direct your attention to a couple of the other provisions in Part 353. In 353.03, the legislature mandated that the critical dune atlas, the map of all the critical dune areas, mostly along the Lake Michigan shore and the lower peninsula, but also in some portions of the upper peninsula and on Lake Superior, that those maps had to be sent to every owner of property within the critical dune areas. That did two things. It put them on notice that their property was limited, restricted. It also put them on notice that all the property around them was protected. We submit that that's significant and has to be considered when looking at the standing provision. In
Mr. Rodo,
section,
I'm going to interrupt you to make sure my colleagues all have time to ask you questions. If they don't, we'll get back to whatever else you want us to hear. Okay, I'll start with Justice Clement this time.
No questions. Thank you.
Justice Kavanaugh.
I have no questions.
Justice Markman.
No questions, thanks.
Justice Zara.
None right now. Thank you very much.
Justice Viviano.
I have no questions as well. Thanks.
Justice Bernstein.
Yes, good afternoon, Council. And I have to say, I think the area that we're talking about is probably one of the most beautiful parts of our state, Circle Beach and Saugatuck. And I guess my question to you would be this, is that in the case that, in the instant case, the individuals in question, no one's ever moved. Those people stayed exactly where they were. The only changes that kind of seemed to take place was kind of with the developer. And I guess my question is that, if the court were not to act, do you see that this could kind of contribute to gamesmanship in terms of how we deal with development projects?
I certainly agree that it could, Your Honor, and the amicus parties made that argument. The responses by respondents to the amicus filing attempted to cast it as if the development community is conspiring, and we've never argued that, and we don't suggest that's the case.
Right.
But certainly where a developer or an owner, of a large parcel has the ability to shield itself from any review, it's going to tend to want to do that. There is, in fact, coincidentally, a new pending case. The primary investor in the Dune Ridge project built his home on Lot 1, and you have maps at our exhibits K and L, and they're included in the administrative record. He built his home on Lot 1, and in the last year, he put in a seawall in front of it. There's a current contested case about that seawall because he didn't seek a permit. It's 600 feet long, 2 parallel lines of 20-foot sheet piling driven into the sand dunes without a permit. He went to DEQ, now Eagle, afterwards, and the department gave him an after-the-fact permit. He's got a motion to dismiss filed, arguing the same arguments that are before this court today. But interestingly, in his brief, he referred back to this case, and he admitted that this case is about the property as a whole, which puts the lie we submit to the argument that they made that there's somehow a buffer, whether through unused property or property that's been sold. So I agree with you completely. It's certainly subject to abuse.
Thank you, Counsel.
Chief Justice, may I go back to...
You may. Go right ahead.
But I invite anyone to interrupt me at any time if you have questions. If I may, because we haven't focused this rigorously on the language of the statute, I'd like to just call the court's attention to 2 or 3 other provisions that we submit work in concert with the standing provision to support the conclusion that standing is held by any owner of property that's nearby and certainly within the same critical dune area. In the permit review provision for Section 1C, the legislature requires that if as few as 2 people who are as far away as 2 miles requested, a public hearing has to be held. In Section 12, local zoning authorities are authorized by the legislature to protect the critical dune areas by up to 250 feet more beyond the boundaries that the DNR defined. These go to a recognition of the importance across an area. The statute is not focused merely on where a hole is dug to put in a fence post or the immediate location of a deck. It's a regional emphasis. That's also apparent from some of the uses of the critical dune area phrase in the statute. In 2012, when the legislature narrowed standing, it left in language that refers to the critical dune areas as unique and irreplaceable. It also added language requiring the department to look at various characteristics of the dunes in reviewing permit applications. And those characteristics go to area-wide impacts. They use the terms diversity, quality, and functions of the dunes. Those same terms and the same mandate for the department to consider them are included in Section 4, permit review, and in Section 17, consideration of variances. So the legislature made it very clear that its emphasis is on the area-wide impact as shown in the definition of use, the activity that requires a permit. Now, respondents argue that in fact, in 2012, when the legislature narrowed standing, it meant to restrict it severely. But the effect of the arguments they made in this case is there would be no hearing whatsoever if their suggestions are followed. And we would submit, as you look at the maps again at Exhibits K and L to our application, our petitioners are as close as you can be. Moreover, to achieve the arguments that they've used, respondents have added words. They suggest that the legislature might as well have said that 2 properties must be contiguous or touching. They even flip the standard around, not saying whether petitioner is adjacent to the use, but rather saying is the developer's property touching the petitioner's property. That flips the standard backward. We would submit that if one considers the change in 2012, there was in fact a substantial narrowing of standing. But the kind of narrowing that occurred was focusing on the local region, not requiring that someone be within 5 feet of a new addition to a house. For example, before 2012, a petitioner only had to be aggrieved. And one can imagine there might be a citizen or a citizens group, for example, in Detroit, Ann Arbor, East Lansing, perhaps in another area of dunes such as Empire, or given the legislature's emphasis on concern for people from other states and countries, someone from Kansas or Great Britain theoretically could have said, we're aggrieved, we're concerned about what's happening in Saugatuck. All of those people no longer would have standing because they don't own property in the critical dune area. Similarly, someone who might live 10 miles east of Saugatuck, who has raised their children going to Oval Beach Park and Hoffmeister State Park and enjoying the dunes, probably would no longer have standing. They may be near, but they might not be near enough because they're not in the critical dune area. Chief Justice, if I may, I would like to reserve the rest of my time. There are a couple other points I'd like to make, but I'm prepared to stop at this point unless there are further questions at this time.
Yeah, you may reserve, absolutely. Mr. Bach, Mr. Konwinski, do you have an order that you're going to proceed in? I assume you're sharing your time.
Sorry. Yes, Your Honor. With the court's permission, I'll go first.
Sure, go ahead.
Thank you. Good afternoon, Your Honors. Dan Bach, Assistant Attorney General, on behalf of the Michigan Department of Environment, Great Lakes, and Energy, or EGLE, also known as the agency formerly known as DEQ. EGLE's position is that this case does not merit further review, and the application should be denied because the Court of Appeals applied Michigan law correctly when it reversed the circuit court and reinstated the holdings of the administrative law judge. Additionally, to Justice Bernstein's question from a moment ago, the issues presented in this application are narrow to the point of being unique and frankly are unlikely to be cured even if the court grants the relief that Lakeshore seeks. And I'd like to talk more about that in a moment. EGLE does not dispute and has never disputed that appellants Zolper and Underwood had standing at the time they intervened in the first contested case and at the time they filed the second and third contested cases. But when the facts changed, EGLE's position changed accordingly. Part 353 requires that in order to have standing, a contested case petitioner must own property immediately adjacent to the proposed use. The plain meaning of immediately adjacent is the parcel next door. Michigan law is clear that standing and mootness are jurisdictional doctrines which cannot be waived and may be raised at any time. And Michigan law is likewise clear that a plaintiff, or in this case a petitioner, must have standing throughout the pendency of a lawsuit unless the case, or else the case must be dismissed. Now, Eagle has acknowledged throughout this matter that the result in this case is potentially unfair to Lakeshore, to the petitioners. However, first of all, this is unfortunately the situation that the legislature created in 2012 when it restricted standing by amending 353.05. It is not the function of Eagle, nor is it the function of the courts to rewrite statutes if it is perceived that they are based on unwise policy or produce an unfair result. Frankly speaking, this is a legislative problem that requires a legislative fix. Now, to the fairness point, it's important to note that Lakeshore has another remedy available to it. Lakeshore has an ongoing lawsuit against Dune Ridge in the Ingham Circuit Court premised on the Michigan Environmental Protection Act, wherein it can obtain injunctive relief to prevent construction of the permitted projects here. Additionally, I mentioned a moment ago the uniqueness of this situation. Part 353 is the only statute that Eagle administers, and it's the only statute that I'm aware of where a person must reside or own property immediately adjacent to the proposed use in order to have standing. We've noted in our supplemental briefing that Michigan law contemplates that equitable principles could be applied in a court of general jurisdiction to prevent a situation like this from arising. Estoppel could be invoked. Unfortunately, the narrow nature of a contested case hearing means that there is no equity. Administrative law judges lack equitable powers, and equitable relief is not available. The administrative law judge was required to apply the statute exactly as written. Also, Justice Bernstein asked Mr. Ordway a question about would this lend itself to gamesmanship? And I think the unfortunate truth is the legislature has created a situation that could lend itself to gamesmanship. But if we envision a scenario where, in this case, had Dune Ridge made the same exact conveyances that it made, but just a little bit earlier, there is no question that none of the Lakeshore petitioners would have owned property immediately adjacent to the proposed use at any point in these proceedings. And so if the court were to fashion a ruling that says in a Part 353 case, an intervener cannot effectively divest a petitioner of standing by selling off its property after the case has begun, it could simply create effectively a game of regulatory whack-a-mole, so to speak, where developers could sell their property before the permits are ripe for challenge and achieve the exact same result. Similarly, it's important to note the permits that were issued by Eagle in this case. There were 10 permits, 2 of which contain special exceptions. Those are included in the administrative record in this matter. Those permits state on their face they expire after 5 years. They were issued in 2014 to 2016. It is likely that some of those permits have already expired. If not, they will expire in the coming months. And so once again, we have the whack-a-mole situation where Dune Ridge, if it chose to, could allow those permits to expire, reapply, and there would be no question that none of the petitioners would have owned property immediately adjacent to the proposed use at the time the new permits are issued in order to file a new contested case hearing. Additionally, I would simply point out to the court, I've spoken a little bit about the narrow nature of this proceeding, the narrow scope of relief available in a contested case hearing. It also merits mentioning that this situation in 9 years since the 2012 amendments has never come up before or since. And so this is a rare, unique situation. It's fact-bound and limited to this one case. And frankly, if the court fashions the relief that Lakeshore has requested, it's not going to solve the problem, either in this case or in any future cases where a developer may attempt to engage in similar gamesmanship.
Mr. Bach, let me interrupt you and see if my colleagues have questions. Justice Clement?
No questions.
Justice Kavanaugh?
None.
Justice Markman?
No questions.
Justice Zara?
Questions, thank you.
Justice Viviano?
No questions.
Justice Bernstein?
Yes, good afternoon, Council. Just a question on that regard is that, based on what you were indicating, had the developer sold the property beforehand, wouldn't that then kind of create, my concern here is that wouldn't this ultimately make it impossible for anyone to have standing as it pertains to developments like this in the future? If under your argument, if it were to ultimately be applicable as it pertains to the conduct and course and nature and scope of developers as they do things prior to construction, wouldn't that ultimately, couldn't we go the other way and would ultimately make the conceptual notion of having adjacent land almost irrelevant and impossible to satisfy?
So if I understand, thank you, Justice Bernstein. I think the issue here, unfortunately, is that the legislature drastically narrowed and created effectively a loophole here that lends itself to abuse. And the point that I'm making on behalf of Eagle is simply that this situation arose when Dune Ridge conveyed away portions of its property after the case had started.
Correct.
We are stuck with the language since 2012 that a contested case petitioner must either be the permit applicant or the owner of immediately adjacent property. Right. And so, unfortunately, Eagle has acknowledged all along it appears to be an unfair situation. In theory, a developer could, prior to obtaining a permit, convey away portions of its property and effectively insulate itself from challenges from the neighbors who reside in that area. Right. And I think Eagle's position is simply that this is a legislative problem, but the language of the statute is plain. It's a problem created by the legislature, and it is up to the legislature to address that problem where the statute is as plain as it is.
Except, Council, I guess my question back to you, and I totally hear what you're saying, and I understand where you're coming from. I guess I would argue, can't you flip it to say that the legislator specifically wanted to give standing to property holders that had adjacent parcels? So they specifically wanted to carve out that right. And the idea that you could have a scenario or a situation develop in which it renders it impossible for someone to actually have adjacent property, couldn't it be argued that would go against the will and the intent of the legislature, as it particularly specified what constitutes adjacent land when it created the dynamic for standing?
It could certainly be argued, Your Honor. I think the issue is that it does not comport, that interpretation does not comport with the plain meaning of immediately adjacent. Now, I want to be clear. There have been two arguments proffered here. Dune Ridge has raised this buffer zone argument, right? That its use is only in the center of its property, and so the other property that it owns out to the property boundary is what's immediately adjacent. Eagle, I hope, has made clear we do not agree with that. We believe that the immediately adjacent property owner is the owner of the parcel next door.
Right.
And the problem is that if a developer conveys away portions of its property so that there is an intervening property owner, they become the immediately adjacent property owner.
Okay.
And so Eagle disagrees with the buffer zone argument that Dune Ridge has proffered, and disagreed with it, took Lakeshore's side in the contested case hearing on that issue. But here, where there is a new property owner who now exists between the parcel on which the proposed use is located and the petitioner's parcels, that appears to be dispositive based on the language of the statute.
I see. Thank you, Counsel.
Thank you, Your Honor.
Counsel, is it your view that they no longer have standing because they're no longer adjacent property owners, or the case has become moot or the contested case has become moot because they're no longer adjacent property owners?
So, Justice McCormick, it's Michigan law says that standing is a jurisdictional doctrine, and if standing is lost, it can be waived or raised at any time and cannot be waived, and it must be maintained throughout the pendency of the case. The federal case law on this appears to say that the federal law is somewhat divided, but the federal case law says standing is jurisdictional when the case is filed, but if standing is lost during the pendency of the case, it renders the case moot. Eagle's position is that Michigan law appears to contemplate standing as jurisdictional, and that if it is lost during the pendency of the case must be dismissed because the court loses jurisdiction. However, we acknowledge that those are two competing conceptions of standing, but the end result under either one is that the case is dismissed if the litigant does not maintain standing throughout the pendency of the case.
So I'm getting to my question. Thank you for the warm-up. So why are any justiciability doctrines relevant at all to a statutory contested hearing issue? I mean, the whole idea of standing and mootness is limits on the judicial power, right? We have limits on what cases a court should entertain and what cases a court can continue to entertain. Those are limits on the judicial power. But here the question is whether a contested hearing should go forward. That's not about the judicial power at all, right? It's about apparently it's about protecting sand dunes, and so the legislature just have given us words to look at, and when we look at those words, it doesn't use standing, it doesn't use mootness, it doesn't invoke for us this invitation to put justiciability doctrines onto this process. Why are we talking about standing at all? Why aren't we just looking at the plain language of the statute as Mr. Ordway presented?
Well, Your Honor, and I want to be cognizant of the fact that I'm going to respond to the court's question. Of course, I don't want to eat into Mr. Konwinski's time more than I already have, but I will say that the doctrine of statutory standing is what we're applying here, and so that requires looking at the plain language of the statute.
Let me stop you. I understand statutory standing, and I understand even in the APA we have statutory standing for when these particular litigants might be able to take a dispute about what happened in the contested hearing into the court. We're not talking about that right now. We're talking about whether they can have a contested hearing. So why do I care about doctrines that are important for limiting judicial power when I'm trying to determine whether or not these folks get a contested hearing in an area where the legislature wanted to protect sand dunes?
And I apologize, Justice McCormick. I did not understand your question at first. I'm sorry.
I probably didn't say it very clearly. I apologize to you. Yeah.
I think the issue is that Eagle's position is that we are applying the plain language of the statute in this case. The plain language requires immediately adjacent property ownership, and that ceased to be present here. When, the requirement that you reside
That
immediately
doesn't say anything about if it ceases to be present, you no longer have a hearing. It doesn't say anything about that. It just says if you are an adjacent property owner, everyone agrees they were, you may request a hearing, everyone agrees they did, and then it says the hearing shall be conducted. I don't see any other language allowing for lost standing to later change the position of the case. I just don't see any language.
So certainly, Your Honor, and I think the issue is that, first of all, the statute requires immediately adjacent property ownership. And so when that ceases to exist, the petitioners have ceased to satisfy the requirement to be the person who can bring the contested case.
They already brought it. They already brought it. The statute just says they can't, if they are that, they may bring it. They did.
And I can also say, Your Honor, that there's a long history of the courts applying standing principles to interpret contested case, the ability to bring a contested case. As Mr. Ordway said earlier, in every other statute that my clients apply, the language is a person must be aggrieved. This court and the Court of Appeals have, for a long time, applied general standing propositions or doctrines to interpret whether a person is aggrieved or not. And
that's
so
that's when they're aggrieved to take the question to the court. I get that. We want to continue to limit judicial power by all the traditional ways when someone's appealing what happens in an APA process. But the question here is who gets the process, the APA process, which is apparently just a legislative process that is intended to protect these sand dunes.
Well, and I apologize for my lack of clarity. I was actually referring to the ability to bring a contested case hearing. So standing is an issue that is commonly raised in administrative contested case hearings, and standing principles. Eagle has argued numerous times and that that, for example, the Lansing Schools case would be applied, generally speaking, to determine if a petitioner is aggrieved to bring a contested case. And so that is neither a new nor a controversial proposition in Michigan law. When we're dealing with a statutorily created cause of action, which a contested case hearing is, we apply the doctrine of statutory standing to determine whether the petitioner can bring it. And I wish to point out two things very quickly, and I apologize, I'm eating up much of Mr. Konwinski's time here. But number one, the statute does not simply say, as Lakeshore has argued, that the case shall then be brought. It says it shall be brought according to the Administrative Procedures Act. So contrary to Lakeshore's arguments, it doesn't say once a case begins, it must conclude regardless of a change in circumstance. That provision simply says this is brought according to the rules of the Administrative Procedures Act, which sets forth the procedures for contested case hearings. And I would also just point out, there are a set of administrative rules that govern EGLE contested case hearings. And those administrative rules specifically say summary disposition is appropriate if there's a lack of standing. And that has long been interpreted under general Michigan standing principles. The one other thing I wish to say very quickly in response to your question, Justice McCormick, is that the plain language of the statute does not at all, as Mr. Ordway has advocated here today, say that immediately adjacent means anywhere within the critical dune area. Immediately adjacent means immediately adjacent to the proposed use. The proposed use is the permitted activity. The critical dune area is a large geographic area that's set forth in the critical dune atlas that's maintained by EGLE. And that would be an extreme inflation or enlargement of the standing provision of Part 353. Unless the court has any further questions, I apologize to Mr. Konwinski. I think I've gone well over. That was not my intent. And I hope the court will not hold my transgression against Mr. Konwinski.
Mr. Konwinski.
May it please the court, your honors. Kyle Konwinski on behalf of Appellee Dune Ridge. The Michigan Court of Appeals should be affirmed. An application for leave to appeal should be denied because the petitioners lost any standing that they had. And I first want to address a few points that have already come up today. And one question that was originally asked was whether there would be gamesmanship if it's found that the petitioners have lost any standing. And I don't think so at all. And in fact, I believe that what occurred here furthers the legislative intent. Let's look at the legislator's intent was to balance economic development with preservation of the dunes. By selling more and more property, a developer necessarily preserves more of the dunes. And so any gamesmanship here is actually going further to preserve any of the dunes from being used. Used is defined as a significant alteration of the dunes. And so I think, in fact, by having this standard, it incentivizes a developer to use, again, using that term as defined, to use the dunes as minimally as possible. And by selling portions of the property, like it did here, very large portions, 20 acres with respect to Miss Underwood and 15 acres next to Mr. Zolper, it preserves additional portions of the critical dune area. And on top of that, as Mr. Bach indicated, it just makes it so that there's a new person or entity immediately adjacent to the proposed use. And in fact, if those properties that were sold are ever used under Part 353, then Mr. Zolper or Miss Underwood can then file a petition for contested case hearing with respect to those uses of the dunes. Another point that was raised is, why do we talk about this in terms of standing and mootness, which are common law doctrines that the courts often use? Of course, I think one maybe practical answer is that those are just terms that attorneys are used to talking about when discussing whether a case like this should no longer be considered, so that we don't consider an abstract idea. But more to the point in this case, legally, this is an administrative tribunal. Since at least 1955 in the Mason case, this court has made clear that the powers and authority of an administrative board must be granted by clear and unmistakable language, and doubtful power does not exist. So the true question is not really whether they had standing or lost standing. It's whether this administrative tribunal continues to have the authority granted to it by the legislator to hear this contested case. And I would submit that they absolutely do not, because the legislator was clear, and in fact was even more clear in 2012, who the legislator wanted to be able to challenge permits under Part 353. And I do want to touch on one point, and that's if we accept the petitioner's interpretation that they want this court to find, it could lead to absurd results and really deter the type of development that the legislator wanted. Kind of as Mr. Bach alluded to, imagine the situation where a petitioner initially files its petition for contested case, and then perhaps the administrative law judge finds that there's no genuine issue of material fact and the permittee is entitled to judgment as a matter of law. Or consider the situation that if a developer doesn't want to be involved in a lawsuit because they're expensive and it's basically a mini trial, and they give the petitioners the entire relief that the petitioners want. Under the petitioner's proposed interpretation, we would still nonetheless have a hearing because they had standing to start. Of course, the legislator didn't want to have a hearing when there's nothing to be decided. The legislator wanted two classes of people to be able to challenge permits: the applicants and the owners of property immediately adjacent to the proposed use. And the petitioners are no longer in that situation.
I'm going to interrupt you, Mr. Konwitzki, and see if my colleagues have questions for you. Justice Clement?
All right, no questions.
Justice Kavanaugh?
I have no questions.
Justice Markman?
No questions. Thank you.
Justice Zara?
No questions. Thank you very much.
Justice Viviano?
No questions.
Justice Bernstein?
Yes, counsel, I'm sorry, I just had to ask a question. So is it your argument, and I have two questions, but I just have to ask this one first, just so I understand. Your argument is, I just was confused. Your argument is that developers in this situation are basically there to preserve the sand dunes and preserve the environment by doing construction and building?
To be fair, no, I don't think so. But I think the way the scheme is set up is to balance preservation with development. And my only point was I was trying to make, perhaps inartfully, was that what happened in this exact scenario is this legislative scheme incentivized us to not use as little as possible. If you're going to develop property, minimize the impact to the dunes. Not only did we do that with respect to the uses that we did do, but also, out of the 130 acres bought, only a small fraction of that is actually being quote unquote used.
And then counsel, if I could, I just want to follow up on Justice McCormick's question, and perhaps she'll probably ask the question better than I will, but I just wanted to make sure it didn't get lost. Can you respond to the notion that basically in the situation we have here, the adjacent property owner at the time, petitioned for a hearing, and why is it that changes? If you're looking at the statute and you look at the language, what changes about it? Even if you sold part of that parcel or part of that property, at the time they petitioned for a hearing. It appears from what Justice McCormick was saying is that the focus was, on the issue of the sand dunes and the environmental impact on the sand dunes. So once an adjacent landowner petitions for such a hearing to take place, doesn't that satisfy the intent of the legislature? I just want to make sure that question got answered, because I just didn't want to make sure it got lost.
Thank you, Your Honor. I do not think the legislator intent is being lost when we find that these individuals, the petitioners, have now lost their standing. And there's a couple points, I think, reasons why. First off, the question is really whether this tribunal was given the authority through clear and unmistakable language to hear this case. And that's a fundamental principle about administrative agencies and what authority they have. And so if we assume, even assuming that, going to Justice McCormick's question, even if we assume that the statute only speaks to at the time of filing a request, then that necessarily means the statute doesn't address after the time of filing the request. And if that's true, then I would ask, what power does the administrative agency have? Where does it come from to hear this issue? And I would submit that they don't have that power. And the reason is that the legislator wanted two types of people to be able to have a contested case hearing. And here, the petitioners don't satisfy that. And I believe, just bolstering the previous point I made, the notion that once you file a petition, you are therefore automatically entitled to an actual hearing, a quasi-trial, and there's nothing in between those two that can eliminate that trial from that administrative hearing from occurring. I don't think that's what the legislator intended, because I think a number of things could happen in between there where the legislator clearly would not want a hearing over.
But my last question is, wasn't the intent to determine the preservation of the sand dune? So it's that wouldn't one argue that that was really the intent of the legislation as it pertained to who can petition for a hearing and why a hearing would be granted?
Well,
why else would you have this if it wasn't to determine kind of the environmental feasibility and preservation of the sand dunes?
Your Honor, I would respectfully disagree. As we cited in our brief, the legislative intent, which is set forth in a statute, says the purpose of Part 353 is to balance preservations of the dune with economic development. So I don't think the only intent.
I see.
If they wanted to preserve the dunes, we'd say, you can't develop anything in the critical dunes, but that's of course not our scheme. Our scheme is private property.
No, I see. But I guess it would come down to how we would both interpret it as it pertains to preservation versus economic development. And that's what, wouldn't one be able, I guess we could see this in a circle. One would argue that basically the intent was to hold a hearing to determine that exact balance. And then ultimately the idea being that the sanding would go to the adjacent landowner in order to trigger the hearing to determine, based on what you're saying, if the balance was appropriate. But you've said, I understand your position and I understand your argument, and I thank you very much.
Thank you, Your Honor.
Thank you, Mr. Konwinski. We are going to go to Mr. Ordway's rebuttal time.
Thank you, Chief Justice. If I may, I'd like to quickly address 2 or 3 points that come up in the discussion by Mr. Bach and Mr. Konwinski, and then circle back to 2 points I think I indicated in the beginning that I'd try to get back to before the end of this discussion. First, I would refer the court to the U.S. Supreme Court's explanation why it did not defer or follow the advice of EPA in the County of Maui case, which had to do with the groundwater issue in Hawaii. That decision was issued in April of this year, and the U.S. Supreme Court said to follow, it was the EPA, but I'll put in the department's reading, would open a loophole allowing easy evasion of the statutory provision's basic purposes. Such an interpretation is neither persuasive nor reasonable. We would submit, and that's 140 Supreme Court, 1462 at 1474. We offer that simply to support the point that the question of standing is a legal question. There's no great expertise within an environmental department to assess issues of standing. This court is far better situated to decide this issue and should not defer to EGLE or the department. Second, the question of gamesmanship has come up several times. I would just point out that in this related seawall contested case, the exhibits that have been used in the motion to dismiss indicate that the owner of the house sold each of the lots, each of the parcels around his house, creating a buffer. However, the exhibits also reveal that they were sold for no compensation, and it indicates that the buyer and seller are under common ownership. So there's an example of, in effect, trying to create a buffer around one's home, presumably in the hope of evading administrative review in a way that's not even a sale to an unrelated third party. Third, Section 2 of the Act specifically, and this is an amendment from 2012, requires the department to coordinate and streamline government decision-making affecting critical dunes, and I quote, through the use of the most comprehensive, accurate, and reliable information and scientific data available. When our contested case proceeds, if it does, that will be the core subject matter, the department's conduct. It was never the goal of petitioners to stop development, to prevent private use, but to obtain review through a hearing and then a final decision by the director of the department of what the agency did in reviewing and considering and making decisions that affect the environment with regard to a sand dunes permit. If I may, I'd like to turn to those 2 points. The statutory language in 35305 starts with owner of immediately adjacent property. Owner is not defined. The common meaning of owner would certainly be anyone who has the right to exclusive use and possession of the property. The question of the application of the Slattery decision of the Court of Appeals has been addressed in briefing, and we would like to emphasize that the words taken out of context of that decision that respondents asked the Court of Appeals to follow, in which it unfortunately did, were contrary to the ultimate holding of the decision. In the end, the Court of Appeals ruled in the Slattery case that the Medials and the Slatterys were both Shorewood shareholders. The Medials had the right to control their property, and they could exclude the Slatterys from parking on the Medial lot. So what's going on is an attempt to apply precedent by taking words out of context to attempt to support a ruling that's contrary to the ultimate holding of the decision. Slattery supports Ms. Hoyt and Mr. Reiniger, brother and sister who own the lot right next to this development. It supports their being regarded as owners, and the same applies to Ms. Shuham, who is just a couple lots further down. We submit that's important not only because Ms. Hoyt and Mr. Reiniger and Ms. Shuham have stood by this process through 5 long years, but also because that sort of abuse of precedent is something that it would be very helpful to the court to address and indicate is not a proper use of precedent. The same procedure is being used in our companion application case based on a different matter related to MIPA and Preserve the Dunes, and I won't go into that, but it's the same issue and it needs this court's attention if you're willing to include that in opinion. Secondly, we've made the argument from the beginning that the common law also applies. The common law, including through a discussion in the Lansing Schools decision of a few years ago of case law in Michigan going back nearly 200 years and talking about the fact that someone who has a substantial interest that may be detrimentally affected, different than the citizenry at large, does have standing. Recently, the Court of Appeals ruled in the Legassic case, and we've briefed this, I don't have the citation handy, it's in our papers, that in a trustee case, the Court of Appeals said, we hold these two hand in hand. The legislative basis of standing and the common law basis of standing, they both apply. Last week, this court declined to accept an application for leave to appeal that Court of Appeals decision. And we submit that the common law also supports the standing of all of these petitioners. But to go back to the beginning of the discussion today, Your Honors, we submit that many of the comments made by opposing counsel today do not address statutory interpretation. The reference to the purpose of the statute being to balance public and private is accurate, but it doesn't get to, and the Court of Appeals in relying on it did not get to, the rest of the statute that emphasizes the importance of local owners of property in the region and the burden on the department to look at effects of a proposed use upon the region. The petitioners, here the appellants, are very grateful for your serious consideration. Thank you for your time and attention.
Thank you very much. Does anyone have any follow-up questions for Mr. Ordway? Thank you all. The case will be submitted.